go. Yep. And we have level. Very good. Excellent. We see you well.
Okay.
Great. Go, Gregg. Gregg Skall is senior partner at the Washington, D.C.-based law firm Womble Carlyle. Gregg's specialty is communications law and Federal Communications Commission law. Gregg, welcome to Access Minnesota.
Thank you, Jim. Good to be here.
As the political season ramps up, we will soon be deluged by a variety of political advertisements, from candidate ads to PAC ads. Tell us, first of all, the difference. What is the difference between an ad sponsored by a candidate's campaign and the so-called third-party ads?
Well, the candidate's campaign ad includes a use by the legally qualified candidate who's running for office, regardless of whether it's in a primary or general election. And it is entitled to, or the candidate or his authorized campaign committee is entitled to lowest unit charge, or the lowest charge for the particular unit of time that they're purchasing. Also, federal candidates, legally qualified candidates for federal elective office, are entitled to access to the station and to reasonably negotiate with the station for the time slots that they want. A PAC, or a non-candidate advertisement, is not entitled to lowest unit charge. It's regular rates, and they buy off the regular schedule just like any other advertiser. But the candidate advertiser is entitled to the same terms and conditions as the most favored advertiser of the station.
And tell us about the non-censorship rules that apply to candidate ads.
I'll
ask that again.
Sure.
Yeah. Hang on, Gregg. I'll ask that question one more time.
Okay, sure.
Now, can candidate ads be censored?
Candidate ads cannot be censored. That is a provision of Section 315 of the Communications Act. And so you cannot, as a broadcaster, taking time or taking placements from a political advertiser, from a candidate political advertiser, you cannot censor the ad. You can't even ask or demand that you see it up front. As a consequence of the no censorship rule, however, you are exempt from liability. The Supreme Court has held that a broadcaster cannot be held responsible for the content of the ad. The only thing that you do have a responsibility for is the sponsorship identification rule, Section 73-12-12 of the Commission's rules. And under those rules, you do have to make sure that there's a proper sponsorship ID. However, because you can't censor it, the Commission has something they have named the one-bite rule. In other words, you can run the ad at least one time just to determine whether or not it has a sponsorship ID. If it doesn't, then you have the right to put it on there, even if it requires covering up or overlaying on top of the purchased time in the candidate's ad. Other than that, you cannot censor it. Non-candidate ads, however, you do have responsibilities as the broadcaster, the same responsibilities you have for other content, and therefore you do have the right to censor it or even to demand to see them in advance in order to assure that they comport with law.
Now, under the no censorship rule for the candidate ads, if the candidate ad includes a vile comment about a minority group or something that is factually incorrect, the station cannot censor that, correct?
That's true. That has arisen in a number of situations, as I think you're aware, and probably most of your viewers are aware as well. We had a situation, for example, in Missouri, where a candidate or a purported candidate was running as a write-in candidate for federal office for Congress. And we were successful in representing the broadcasters of Missouri in challenging the bona fides of that candidacy, and the candidate was not deemed to be a bona fide candidate, and therefore access was not required to be given to him, and you didn't have to run his ads, which were very racial, very much. Most broadcasters did not want to broadcast it. We have another situation in the current election cycle. Randall Terry is purporting to run in some states as a write-in candidate, in other states as a registered candidate for the Democratic primary for president, and his goal is to broadcast abortion ads, live abortions in his advertising, in order to try to shock people into some sort of reaction against allowing abortions. And a lot of broadcasters have reacted. They did not want to run those ads, and the FCC recently issued a letter with respect to his purchases in the last Super Bowl, in which the commission said that we don't have to reach the question of whether or not he's a legitimate candidate or not, because we don't require you to sell time in so unique a program as the Super Bowl to a legally qualified candidate. So that situation was averted, but we do have him continuing to demand time in some other states. Depending on the state and depending upon the broadcaster's stomach for confrontation, some have run it and some have denied him access.
Gregg, how is it determined whether or not a candidate is bona fide?
There's a variety of tests, but under the Commission's rules, if you are properly registered and qualified for placement on the ballot according to the state in which you're running, and that's usually a qualification in the Secretary of State's office, then you are deemed qualified under the Commission's rules. If you are not yet qualified under the Secretary of State's office, or don't yet have a place on the ballot, or maybe it's before those registrations are permitted, then there's a three-part test that the Commission employs, which includes your declaration of candidacy, conducting activities that are consistent with a full-blown candidacy for the area and the office that you're seeking, and otherwise conducting those kinds of activities. So that's the test. It's a factual test that you would have to meet in order to be considered bona fide.
Gregg, let's talk a bit about
equal. You have to be legally qualified. Otherwise, for example, if there's an age limit or some other residency requirement or something like that.
Gregg, let's talk a bit about equal access. Say, for example, this came up during the Reagan campaign. Ronald Reagan, of course, an actor. A TV station airs the movie Bedtime for Bonzo. They suddenly have to provide equal opportunity to his opponent, correct?
That is correct. If you are a legally qualified candidate and you have opponents for the same office you're running for, and remember, in a primary, for example, the opponents are your other candidate, your other opposing candidates in the same primary, not somebody you might later meet, you might be later opposed to in the general election. But your legally qualified opposing candidates are entitled to equal opportunities. They have to be claimed within 7 days of the prior use, and it has to be a positive use in order to claim equal opportunities. For example, if something is negative about the candidate who's running, and the candidate appears by a recognizable image or voice, then his or her opposing candidate can't claim equal opportunities unless the prior use was positive, not negative. In the case of Bedtime for Bonzo, where Ronald Reagan was running for governor in the state of California, there was a claim made by his opponent for equal opportunities for the length of the film. And that matter never reached a written decision. It was negotiated out, but it serves as one of our prime examples when we talk about this topic.
Did anything similar happen with Sonny Bono when he was running for Congress? Sonny and Cher song, did that trigger any of his opponents to cry for equal opportunity?
You know, not that I can recall off the top of my head, but it would. if a radio station, for example, did play a Sonny
and Cher.
Sonny and Cher, thank you. I guess my age is showing. Sonny and Cher song, and obviously would be recognizable. His voice would be recognizable. Were he still running for Congress, alive and still running for Congress, then yes, they would be entitled to equal opportunities. It comes up today in situations a lot where news anchors or news reporters run for office, and you have to deal with a situation where they may otherwise appear in a news program or reporting the news or however otherwise appear on the station. Generally, stations either have to take that person off the air or they have to negotiate, and you can negotiate away your equal opportunity rights or negotiate them to something else reasonable. So the station will sometimes contact the opposing candidate with the suggestion that they negotiate something out that would work for both parties.
Now, if a candidate appears on a news program or is a guest on a show like Face the Nation, a talk show like that, does that open up equal opportunity issues?
Generally, no. As long as it is a bona fide news program, news interview program, news documentary, or news reporting, on-the-spot coverage of news, those are the categories that are exempt from equal opportunities. But that has to be bona fide. And by bona fide, the commission generally means for the value of the news in the stations or the licensees' best judgment, and not for the purpose of advancing the candidacy of the candidate who might be appearing.
In your judgment, Gregg, as an attorney, where do you see broadcast stations usually getting into trouble with political advertising?
They sometimes get into trouble in trying to figure out their lowest unit charge because it's really important to make sure that you have properly calculated it and that you have looked in advance to determine when an ad that is purchased maybe a long time ago is going to run. Because if it runs in the 45-day window before a primary or the 60-day window before a general election, then it will determine what the lowest unit charge is for that particular week in which it runs. So sometimes stations seem to think that they have a rate card. They can just show it to people, and that will determine what their rates are or what their lowest unit rate is. And it's really a much more dynamic process, and you have to determine what it is based upon the advertisements that are actually running during the same week in which the political advertiser runs. Another area where they run into problems sometimes is in disclosure. When I do a seminar on this, I like to analogize to the three basic rules of real estate development: location, location, and the third rule is location. And in political advertising, the three rules are disclose, disclose, and disclose. You have to treat a political advertising buyer, whether it's the candidate or somebody buying for them, or even somebody who's buying for them who is a seasoned advertising buyer, agency. You still have to disclose everything that a neophyte time buyer would need to know in their reasonable judgment or in your reasonable judgment, so that they have fully all of the facts they need to make an informed decision on what time to buy, what classes of time, and so on. Another area where broadcasters run into trouble is they create classes of time that include group discounted for volume, because generally that's the way they sell time to commercial advertisers. But volume discounts or any kind of rotations or clusters that are based upon volume is not a valid class. Other than that, the commission will basically allow the broadcaster to determine their own classes of time based upon any reasonable judgment that actually creates a different right or a different benefit to the person who's buying that time.
Gregg Skall, senior partner at the Washington, D.C.-based law firm Womble Carlyle. Thanks so much for joining us on Access Minnesota.
Thanks for having us, Jim. I appreciate it.
Thanks, Gregg. Worked well. We'll let you know how it turns out.
Okay, great. Thank you.
We'll talk to you soon.
Take care.
Bye.
Bye.